Molweni, ndiyathemba niyaphila. I saw this comment a few weeks ago. Someone asking me to explain IRAC, FIRAC, or ILAC. So these are the same thing, by the way, but some people call it different ways. So it's a method that's used in law on how to answer questions in certain law modules. Not all law modules require this method, but some do, probably most of them, if not 50-50. But on IRAC, I stands for issue, R stands for rule of law, A for application, C for conclusion. So you first identify the issue, and then on rule of law you state the rule of law that applies to the issue that you have identified. And then A, you go to application, you apply the rule of law that you have identified to the set of facts, and then link it to the issue above. And then C stands for conclusion. That's why you conclude. Maybe the question said you should advise someone on something. Yeah, here's an example. An example of how IRAC works is, let's say you are given a question or maybe a scenario. So now you identify the issue as let's say the issue is, okay, let's do criminal law, maybe criminal law. We identify the issue as maybe culpable homicide, right? Culpable homicide, okay, so it's culpa. And then on rule of law, that's where you state the relevant authority, legal authority that applies to culpable homicide. Let's say you state the case of S versus Humphreys or something, or the Jub case, you see. What else? But those cases, now you said, okay, in the Jub case, this so and so was stated. In the Humphreys case, so and so was stated. And then you say maybe section 14 of the Criminal Law Amendment Act. I don't know what section 14 is, but I'm just making an example. Section 14 of the Criminal Law Amendment Act states so and so. Section 9 or section something of the Constitution states so and so. And then you move on from your rule of law. You go to the application. Oh, man, I feel application. Yeah, application. And then in application, you apply the rule of law that you have identified. The rule of law that you said is relevant to the issue that you have identified. So now, let's say you apply it. You say, okay, in terms of section 14 of the Criminal Law Amendment Act states that, therefore, in this case, let's say King killed someone without planning it. There was no premeditation. Maybe it doesn't satisfy the elements of a crime. Remember, you have stated the elements of a crime on rule of law, all those elements of a crime, intention, all those things, and then you state those dollars, indirectors, so you apply it, and then say, in the case of so and so, the court concluded as this, so therefore in this case there was so and so King Warawara, you state it, and then after applying now, you go to your conclusion. That's where you conclude and say, okay, since this so and so and so, considering what we mentioned above, the conclusion or my advice, maybe the question said you should advise. My advice is that so and so should do this, or maybe it's conclude, okay, say it's couple homicide, maybe, you see, or maybe it satisfies what something like that, just to say it does constitute a culpable homicide. I thank you.